in association with Anand and Anand, had organized a webinar series titled Knowledge Series on Law, Intellect and Property in the month of October 2020. Leaf 1, which was the inaugural session, was delivered on October 10, 2020 on the topic Understanding the Basics of Patent Litigation. We all thoroughly enjoyed the session, which was delivered and further deliberated upon by Mr. Shravan Chopra, partner, Mr. Dhruv Anand, partner, and Mr. Vibhav Mittal, managing associate at Anand and Anand. And the session was very well moderated by Ms. Riddhi Bajaj, senior associate, Anand and Anand. Today, we all are meeting again for Leap 2, that is session 2, as part of the series. We have among us three resource persons, Ms. Tusha Malhotra, partner, Ms. Prachi Agarwal, partner, and Ms. Udita Patro, the managing associate at Anand and Anand. Today, okay.
So we were not able to hear you.
Okay, I'm audible now, Mr. Devesh?
Yes, you're audible, sir.
Okay, so you did not hear to anything what I said, right?
Sir, towards the end.
Towards the end. Okay, the end was that I welcome you and please take over the baton and take the session ahead.
Thank you, sir. Thank you for the introduction. Hello, everyone. I'm Devesh. I welcome you all to Leaf 2 of Knowledge Series on Law, Intellect, and Property. I will just briefly explain the rules first, then the format that we'll be following today, and then I will introduce the speakers today. So the brief rules would be that all attendees are requested to be on mute throughout the session and the video turned off. At the end of the session, we will have a question answer round where you can put up your questions to the speakers. You will raise your hand, and once allowed, you can unmute yourself and you can switch on the video. We will be following a different format today, which was different from the previous one, which will be a presentation model. So in Leaf 1, on the previous Saturday, we had discussed about the basics of patent litigation. Taking it forward from there today, we will be discussing about the enforcement of drugs and pharmaceutical patents, and we will also understand the concept of territorial jurisdiction in IP suits. So we have three eminent speakers with us today. Ms. Tusha Malhotra, who is partner at Anand and Anand. She studied law at the Faculty of Law, University of Delhi, and she has over 10 years of experience in IP litigation. She's been involved in one of the most landmark cases in patent litigation, which is the Novartis versus Union of India, in which it was for the first time that Section 3D of the Patents Act was interpreted. And we will be discussing that during the presentation as well. Along with her, we have Ms. Prachi Agarwal, who is also a partner at Anand and Anand. She studied law from National Law University, Jodhpur, and thereafter she obtained LLM in intellectual property from the George Washington University, US. She's been part of the landmark Roche versus Cipla litigation that involved numerous aspects of patent law. Our third speaker today is Ms. Udita M. Patro. She is the managing associate at Anand and Anand, and she has a master's in science in biotechnology. Thereafter, she's completed law from Campus Law Center, University of Delhi, and she's been a litigator for the past 9 years. She's been part of various landmark litigations in copyright, trademark, and patent, including the Merck versus Glenmark patent litigation, which we will be discussing during the presentation today. So let us begin with the topic, the enforcement of drugs and pharma patents. We will learn about the depiction of claim, some basics, the criteria of grant of a pharma patent, and then we will move on to the enforcement of pharma patent. What are the rights involved? What are the reliefs that can be claimed? What are the enforcement actions available under the Indian patent law? So over to you, Tusha ma'am and Prachi ma'am.
Devish, I think Prachi has to start. Has she? If you could confirm if Prachi is there.
Yes. She has to, and she has. I think.
Can everyone hear me?
Yes,
Prachi, we can hear you now.
We can hear you.
Okay, thank you, Devesh, for the introduction. Good afternoon, everyone. So today we'll be talking about enforcement of drugs and pharmaceutical patents. Now, for the benefit of everyone who doesn't know what a patent is, I'm just going to quickly define what a patent is. A patent is basically a monopoly right which is granted for inventions. And this monopoly right is for a period of 20 years. And it's basically the main objective behind a patent right is to incentivize development in science and technology. So whatever we are using on day-to-day basis, most of it is covered by patent. And there's a reason why it is there, because there is an incentive which is being granted in the form of patents. Now, talking about pharmaceutical patents, Devesh, if you can go to the next slide, please. Yeah, next. So what is a pharma patent? A pharma patent is a chemical patent, pharmaceutical patent, or a drug patent for an invention in the chemical or pharmaceuticals industry. So simply being put, all your medicines which you're consuming, they all are protected. They are all inventions which are protected by a pharma patent. Now then the question arises, why are we talking about pharma patents specifically when there is already like general provisions available for patent? Why there's a special consideration which is given to a pharma patent? Next. So the reason, what is the peculiarity of a pharma patent is it involves unpredictable arts. So most of these inventions involve a lot of reactions between complex molecules when a medicine is being prepared. And these reactions are unpredictable because there is a lot of, the molecules are complex, the temperature, pressure, variation, the concentration, what catalyst you're using. Then after that, once that is done and you have a candidate which is showing certain kind of effects towards curing an ailment, it has to be also tested on the body, whether it's not having any side effects. And because this process is so tedious and complicated, the drug discovery and drug development process is extremely long and time consuming. In fact, on an average, it has been said that it takes about 10 to 17 years to develop a drug. And a perfect example is that, we are still finding a vaccine for COVID-19 right now. Like there are about 42 candidates in the market which are showing some promising effect. But as of today, we don't have a vaccine for COVID-19, and all the big pharma companies are working towards it. And which also means that because this process is so tedious and there's a lot of clinical trials which happen, which means that the drug is tested on people. So to show whether there are no side effects, whether it's actually curing the ailment, there is a huge investment and huge R&D cost which is involved. The another peculiar thing about pharma patent is there's always an issue of public interest, because when you say that some invention is protected by a patent, obviously there's such huge R&D cost. So sometimes because the cost is high, or it's very difficult to manufacture large quantities of the drug, so there is always a concept, there is always an issue whether the drugs are going to be affordable or accessible or even available to the public, and whether they will be able to afford this kind of medicine. So there's always that public interest angle which is involved. Of course, if you look at the Patents Act, there are a lot of provisions which are there. So for instance, there's compulsory license provision which is there. And in fact, if there is a public health crisis and there's extreme urgency, even the government can take steps in this regard. In fact, recently India even approached WTO to say that, maybe, all inventions or patents pertaining to COVID-19, maybe there should be some kind of a measure to in a limited way to suspend intellectual property rights related to it. So that is something which is still under discussion. You can go to the next slide. Now, what are the different kind of inventions we can have in the pharma industry? One is a new chemical entity, which is basically a drug. Then you can even have salts, because sometimes, if you have a drug per se, it may not be stable. So you might have a chloride salt of it or a sulfate salt of it just for stability. So your invention could be a salt of that particular drug. Then process to manufacture a drug. Then there can be polymorphs. Now, polymorphs are basically, there are certain products which are crystalline in nature. They exist in crystalline forms. So it's basically arrangement of molecules. And sometimes it's seen that if you have a particular crystalline structure, it is more stable, or it is, the delivery of the drug is better in the body when the same is administered to the. Then there are some formulations patent. These are usually mixtures, and again, sometimes a non-reactant is used just for the delivery purpose, so that the drug can be again administered into the body of the patient. Sometimes there can be a combination of two molecules. So a perfect example would be Combiflam. Like Combiflam is actually a combination of ibuprofen and paracetamol, which has been put into a single pill. So which means that, you can take one particular drug and it can help you in more than one way. Next slide. Now, what is more, so just to give a brief idea, when you have a patent has different elements when you write a patent, and claims is actually the most important, because claims actually define the scope of protection. So when anybody who's drafting a patent, it's very important that you should know that your claim should be broad enough to capture your invention, so that if somebody copies it tomorrow, you know that you can take an action against. But at the same time, it should not also be too narrow. So it's very important, but the entire crux is that you should know where your invention lies, and on the basis of that, your claims can be drafted. Next slide. Now we spoke about a new chemical entity. Now this is an example how we can depict a claim of a new chemical entity. Now this is actually an example which has been taken from the landmark decision of Roche versus Cipla. Now so there are different ways in a new chemical entity can be depicted in a claim. One is that you can use a chemical name. The other is you can define it by a structural formula. Now these are this is basically the structure of the drug which was being used for anti-cancer. And this is what the claim looks like: a novel 6,7-bis 2-methoxy-ethoxy quinazoline 4-aryl 3-ethanyl phenyl amine hydrochloride compound of the formula A. So it's actually hydrochloride salt of this particular structure. Next slide. Now, interestingly, now if I look at the previous structure, Devesh, if you can just go back for a second to the previous slide. If you can see in the center of the structure, there is NH. Now my drug here is very, very specific. There is only one drug which I am claiming here in this particular claim. Now, what if I replace this NH and go to the next slide with X, and where I define that X is chlorine, bromine, iodine, nitrogen, sulfur, and this list can go on. And not just NH, I could even replace any of the other substituents. Now, the moment I do that, my invention or my claim becomes broad to include all the drugs where there may be a chlorine in place of X, or there may be a bromine or nitrogen. So this is actually a MARKUSH structure, and the whole idea behind this structure is that whether I put chlorine, whether I put bromine, all of these structures will have anti-cancer properties, or whatever the drug may be for. Basically, they have similar properties and they are bound by a similar structure. Next. So what is a MARKUSH claim? A MARKUSH claim is a chemical structure depicted by means of symbols indicating substituent groups. A MARKUSH formula share a common user property and it shares a common structure, as we just saw in the previous slide. Next slide. There are other ways also of depicting claims, like I spoke about in my previous slide. What are different kind of inventions which can be there in the pharma industry? So if I see the same structure which we saw 2 slides back, I could even claim for a novel crystalline polymorph structure of the same. But again, like I said earlier, it depends on what my invention is. If my invention is specifically for a polymorph, I can have this as one of the claims or the basic claim. If my invention is for the drug, and that's where my invention lies, and that's what I want to protect, then I will go for the drug. If my invention says that, you know, there are not just one, there are multiple drugs which are bound by same property and same structure, then I can have a MARKUSH. On the right side, you can also see that there is a process for preparing the compound. So I can even claim a process of manufacturing the drug. Now, sometimes in a single patent, I can have multiple claims also. I can have a base claim, which can be my independent claim, and then I can have many other subsequent claims where I'm not only claiming the structure, I might also be claiming the process of making that drug. I might be even claiming a polymorph for making a polymorph of that particular drug. Next slide. Now, what is the criteria for grant of a pharma patent, and what are the challenges? Now, obviously, if you're getting a monopoly right for 20 years, there has to be certain criteria, because otherwise, you know, you can't just come up one fine day and say, I have an invention, you grant me a monopoly for 20 years. So now what are those criteria? Now, if we start with the first criteria, this is novelty. Now, if you look at section 21J of the Patents Act, it says that the invention has to be new. Now, what is important for all of these criteria is the priority date. Priority date is the date of the first filing. It's the first filing date of the patent. So anything before that is what you have to see, which is the prior art. You have to basically see whether, as on that date when I filed my first application for that invention, what all was in existence, and if I compare my invention to whatever was in existence before the priority date, is my invention new? So anticipation by previous publication. So whatever publications which are there before my priority date, whatever is in the public domain, everything has to be looked into to see if my patent is novel. You can also see if somebody else has claimed that particular invention in a previous patent. Now, it is a factual inquiry which I have to see. So when I look at the prior art document, which means any published document which is, or a prior patent application which is there, what I have to see is that there's a clear and unambiguous disclosure. And I have to look at a single document. So all the elements of my claim have to be in a single prior art document. Now, this is the decision of the Bombay High Court, which basically said the same thing, that you have to look at one particular, you cannot combine prior art documents and say, okay, you know, one element is in this X document and the other element is in this Y document. For the purpose of novelty, you have to look at just one single document. Next. Inventive step. Now, inventive step is the second criteria which has been provided under section 21JA of the Patents Act. Now, what the definition is, that the difference between the claimed invention and prior art is such that it would have been obvious at the time the invention was made to a person having ordinary skill in the art. Now, it is different from novelty in the sense that multiple prior art documents can be looked into. So you can basically combine the documents. Now, what is a person of ordinary skill in the art? You have to see what your invention relates to. So, for example, if it is a medicinal product, you have a person of ordinary skill in the art would be a medicinal chemist. As also said by Roche versus Cipla decision, you cannot say that, oh, somebody who's excelled in the field of making turbines. You have to see from his point of view. So, what is a person of ordinary skill in the art? Person who practices in the relevant field of technology, belongs to the same industry as the invention, possesses average knowledge and ability. Like, he doesn't have to be a super scientist or someone who has, above average intellect, and should be aware of common general knowledge at the relevant date. Next slide. Devesh, next slide.
I believe there's a lag.
Sure. So when we look at inventive step or obviousness, again, you have to look at the prior art, which I stated earlier, everything which has been published before your first filing date of the patent. So the moment you look at a prior art, you have to see what is disclosed. Is there any particular drug or a structure which has been disclosed? Is the process of making that particular drug disclosed? Is there any property? So, for example, if I'm looking for a drug for the ailment of anti-cancer, for ailment of cancer, it's an anti-cancer drug. So, when I pick up a prior art document or a publication, I have to see whether the molecule in question, whether it even has any anti-cancer properties for me to even start working on that particular drug. Then you also have to see whether it has any negative effect. Now that drug in question, which has been disclosed in the prior art, it may have anti-cancer properties, but what if it's, it cannot be used on, say, pregnant women or old people, or it's causing like other side effects, like nausea or any kind of, negative properties. So you have to see that as well. Now, structure alone is not enough. Now, what does this mean that structure alone is not enough? Which means if I name a particular drug in a prior art document, if the drug is named or the structure of the drug is there, that alone is not enough. I can't just, there has to be some data to support that this structure of a particular drug, it has anti-cancer properties, or it has a potential for treatment for diabetes. So there has to be some kind of teaching or suggestion or motivation for me to pick up that particular drug in question, start working on it, and modify. And the way I'm modifying, that modification also, there must be teaching for it to be obvious. If I am doing my own experimentation out of the way, and then I come up with an invention, that would not be obvious. There has to be something in the prior art. So, and there cannot be a hindsight analysis. So I have been stressing on the fact that I have to go back to the priority date and look at the publication. So if I look, say if my invention was made in 1995 and I look at it at 2005, now 10 years later, all of us are definitely 10 years more smarter. There's more technology which is there in the public domain. I cannot look at the technology now, or I cannot look at my smartness now and go backwards and say that, okay, this would have been obvious. I have to go back in time, look at what all was taught in the prior art at that time, and then I need to see whether it was actually obvious. So there cannot be any hindsight analysis. Now, sometimes there's secondary considerations as well, which means, sometimes this is long felt need, failure of others, or some drug which may show unexpected results. So these can also be considered to show whether it has been obvious. Now, in the Roche versus Cipla decision, of course, this was discussed at length, and I'll just say it in brief. So the invention was, as you saw, it was an anti-cancer drug. And the prior art in question, which the opponent had cited, they were saying that there's one change, there's one molecule, one substituent different, one functional group which was different. But the judge said that no, this is a typical hindsight analysis, because when you look at that prior art, there's no teaching for any person of ordinary skill in the art to pick up that particular drug and make that one change. In any case, one change does not always have very expected effect, as we saw how chemistry is unpredictable. You can go to the next slide. Now, the next slide. Yeah, the third criteria is utility. You have to show that there is some, the invention is in question should be capable of being used in an industry. And the threshold of utility is extremely small. The only thing is that there must be some kind of a promise or potential benefit. It doesn't have to have any kind of commercial application. It doesn't have to be like marketed as a drug. It doesn't even have to have any practical utility. You have to basically see what your specification, your patent has promised, and only mere possibility of use is sufficient. And all you have to show in your invention is, or in your patent is, that there is at least one use of that particular invention. So of course, if you want to really understand all these concepts of patent litigation, and particularly for pharma patents, I would recommend that you should definitely read the Roche versus Cipla judgment, and you will find all of these principles which have been discussed in detail and have been applied to the facts of the case. Now, I would ask my co-panelist, Ms. Tusha Malhotra, to take over from the next slide. Thanks.
Thanks, Prachi. So, Devesh, just let's move to the next slide.
Yes, we are on section 3D side.
So, like Prachi told you, till about 2012, 2013, there were but understood three criteria for grant of a patent, which were what she took you through: novelty, inventive step, and utility. With Novartis versus Union of India, the peculiarity of the patent, special patents, especially in the chemical and pharma field, they came through, and section 3D was added as an additional test. That means if you need to get a patent in this field of chemicals, and 4 tests have to be satisfied before the application is proceeded. The 4th being section 3D. Now, what is section 3D? Most of you who would have had some primary courses taken in IP law and patent law would have had the benefit of going through section 3D. But let me just once again, in brief, bring it to all of you what 3D is. It's basically a 3D is a deeming fiction, which means that the second generation patents where it is primarily applied to. What happens there is a new form of a known substance is deemed to be the same known substance unless there are some changes or enhancements that can be seen from the known substance in the new form. Why I'm saying this is application, this provision applies to the second generation patents is also very well clarified in Roche versus Cipla, where it says that second generation patents, which could also be new forms, which can be seen from the frame of section 3D. Those new forms, which are defined in the explanation of section 3D, being a polymorph or an isomer or a salt, or things like that. So there's an entire list in the explanation to section 3D. All those things are qualified for a new, provided there is an enhancement in efficacy shown from the known substance. Now let's just see. Let's break down section 3D. 3 major prerequisites or hurdles which have to be crossed. There has to be an identification of a new substance, a known substance. What is a known substance? It is a substance which is closer or the closest to your invention that you've applied for. This substance, this known substance has to be disclosed in prior art, which in most of the cases you will, in practical life, you will find it in the MARKUSH patent, which Prachi just explained, or let's just call it for the ease of convenience, the parent patent. You will find it there, and there has to be a clear disclosure of the known substance. Now, this known substance by itself may not. You need to have a known efficacy, which is the known result this substance or the known activity this substance is desired to bring. This has to be ascertained or disclosed. Ascertained, when I say is ascertained, it can be freely ascertained from the prior art or your what we called as parent patent a few moments back. Then the third limb, which is actually taking the hurdle, crossing the hurdle for the new patent invention, the invention that you sought patent for, which is that there has to be an enhancement of known efficacy of this known substance which has been identified from the prior art or the parent patent. This enhancement of known efficacy, what that really means in pharma and chemical parlance, this efficacy is supposed to mean therapeutic, and that is again one of the findings in Novartis versus Union of India. Now, what is therapeutic? It's not any activity which may better the invention that you have sought patent for. It is activity which is biological in nature, which gives a higher or an enhancement effect of treatment of an ailment which the new invention is aimed at. We discussed that this has an application in on the second generation patents or not, where there is a new chemical entity found. Now let's just take a little practical view of the pharma industry, and I'm telling you the most basic practical view of the pharma industry. What are the first challenge is to find a molecule which will bind at the receptor. Now, this molecule, it works like we've all at certain stage in our life, we've read about the lock and key mechanism in the science and how the biological activity in the body is brought about with the lock and key mechanism. Let's see the receptor is the lock and the molecule is the key. So we need to find that key to the lock, which will actually treat or have an effect on curing of the disease. Now, that's the first hurdle. The second could be where you need to bring up a drug product in its stable form, which contains the molecule, which may contain other excipients. That molecule, I mean, is the key and the other excipients. and make it in a stable form so that it can be kept on the shelf, which can be brought to the patient later. That could be the second hurdle. The third hurdle is to be able to deliver that through the log, through the digestive tract of the patient after it is consumed, so that it is not broken down or it's not unaltered, or it reaches the binding site or reaches the log in an unaltered or unharmed form, so that it can do its job, which is take care of curing of the ailment that it is intended to do. Now, that's each of these three things that I identified right now for the purposes of our discussion. Each may require long research, very time-consuming, long. Of such steps may have, may satisfy the patentability criteria, although they may be a manifestation or an improvement of the main key, which is the molecule which is going to bind with the receptor to bring about curing of the disease or the ailment. This, like I told you at the beginning, is the most simplified practical scenario we've taken of the pharma industry. Trust me, there are many more complexities that the pharma industry goes through before one successful drug product reaches the shelf and is brought to the patient for treatment of the. I can go being a part of Novartis versus Union of India. I can go on spending my entire session on this slide, but we'll just keep it right now at this level and can take more questions if there are any more which comes, which the participants want to address. Devesh, can we move to the next slide, please? Okay, there's a lag. Has it been moved so I can start? Can someone confirm?
We are on the slide for rights in the patent enforcement.
All right, thank you. Now that we have crossed the criteria of or the tests of grant of a patent, and we have a granted patent. Once the patent is granted, what are the rights that we get from the patent? Devesh, just move to the next slide. If the introductory slide still shows up on the screen. Now, what are the rights? And when do the rights? I'm just going to address the rights in sort of three general headings, being when do the rights accrue, what are the rights, and when can we start with the enforcement. Now, let's start with what are the rights. We all have, at some point, who have taken an IP course or a patent course, even at a very preliminary level. We've read a patent right is a negative right, or in other words, an exclusionary right. What does that mean? That comes precisely from the framing of Section 48, which imparts or grants rights to a patentee once the application for patent is sealed and granted. How does Section 48 read? It starts as that it is an exclusive right to prevent third parties, hence an exclusionary or a negative right, from doing certain acts, which are making, using, offering for sale, selling, or importing for those purposes that product in India. Well, we can all read what the provision reads like. Since I do bring some industry experience on or practical experience on the table in the session, I just want to highlight one more thing for everybody to notice. The word exports from these rights are missing in the provision. There are some schools of thought which say that using and selling would include exports. There are cases which indirectly reflect on it, and there are cases which do not directly reflect on it. So this point of exports, whether it is encompassed in Section 48, is still not clearly stated in any of the leading cases in India, or in any case for that matter. Now, when do these rights that accrue on the date of sealing of the patent? Now, there has been some issue about the date of grant of the patent. If anybody has interest in that, may I suggest reading of Snehlata Gupta's order, which does then give clarity on when is the patent considered granted. Case clearly says that the patent is considered granted on the date when the controller who is examining and passing orders on the patent application in question passes a final order for grant to that effect on the file. Maybe it seems very obvious that should be the date. But often what happens in a practical scenario is between the date of signing off the final order or passing of the final order to when it is reflected on the register, there is an administrative lag. There could be an administrative, and that lag, Snehlata Gupta clarified, that lag should not be considered. The rights should be seen from be accruing on the patentee on the date when the controller passed the application in order and proceeded it to be granted. Now, when can these rights be enforced? Section 11A or 7 of the Patents Act says that the rights and any incentives for a patent applicant accrues from the date that application for patent is published. However, on the date of publication, there will only be rights, but not merely enforcement. Because Section 11A7 says that the lawsuit for enforcement of a patent can only be filed once the patent is granted and not on the date of publication. Therefore, what is the application? If there is infringement which occurred between the period of publication and the grant, the patentee will only file the lawsuit after the date of grant, but can claim damages from the date of publication of an application of the patent in question. Now, that's what the scheme of the Act says. However, there has been a recent concept, it's kind of a twist, which was given by Supreme Court in an Enacon case, with an introduction of a concept of crystallization of rights in a patent. Now, what is crystallization of rights? You won't find this concept or this expression anywhere in the Patents Act. But the Supreme Court threw some light on this concept, which means the rights of a patentee in the patent in question will be considered crystallized only after lapse of 1 year from the date of grant of the patent or disposal of a post-grant opposition. Well, for everybody's information, the time or the window to file a post-grant opposition against the patent is 12 months from the date of grant. So again, 1 year till the disposal of the post-grant opposition. And within this period, now this is the interesting part, the Supreme Court says within this period, it is unlikely that a lawsuit for infringement will be filed. Well, it doesn't negate an option of filing of a lawsuit, but it says it is unlikely. Now, this twist is still being debated in a lot of cases in court, and one of the decisions in Novartis versus Natco, Justice Pratibha Singh did throw some light on what would have meant by making that statement. Of course, her entire endeavor in this decision was to read the Enacon observation harmoniously with the scheme of the Act, and she said that the rights accrue on the date of grant of a patent, but they may crystallize at a later date. However, it doesn't stop. Nothing stops a patentee from filing a lawsuit after the patent is granted. So that is what came about on the concept. But again, like we said, we will find a few cases, but the jurisprudence right now is not really settled. People, there are arguments on opposite directions, and we are yet to see if there is one larger bench or the Supreme Court gives a clarification on that. We are yet to witness that day. Well, on the question of now, this is a concept which, again, I'm going to bring a little industry perspective here, since some experience of the courts can be shared with everybody in the room right now, which is Section 13(4). Basically, if you have if people have read Section 13(4), it's a kind of an immunity given to government offices and officials from being in any way dragged into any sort of liability or proceedings for granting a patent. Now, what does that mean? What does it say? It says that you can't drag a government official. There will be no presumption of validity for grant of a patent as against a government official or a government office. There will be no liability. Now, this unfortunately has been misread in a lot of cases and clarified in one case or a couple of cases. So the jurisprudence initially went in the direction that Section 13(4) says that there is no presumption of validity of a patent. So despite a grant, despite the stages of challenges that a patent application may have gone through to be granted, to be considered to be fit to be granted as a patent, it may still not be valid. It will not be on its face, that certificate will not be proof that the patent is valid and is not liable for challenge. This is on that validity, lack of validity. It can't be assumed that an injunction can be granted because there is no prima facie presumption of validity of patent under Section 13(4). We've seen a couple of cases in the recent past which do say that 13(4), the real intent was to give immunity to government officers and government officials. And there is another case, where the true import of 13(4) has been recognized as Justice Waziri's decision in the Erickson case. And there's yet another case where, in a FISA case, where the court did say that if there is no presumption of validity, of course, there is no presumption of invalidity as well in a suit of infringement. There has to be the tests satisfied, a prima facie credible challenge to the validity of a patent be established in order to refuse any merit to the patent. Devesh, can we go to the next slide?
Yes. Okay. We'll come to infringement slide.
All right, moved. Now we've understood what takes to get a patent. We understood what rights accrue from a patent. And in most of the cases, I won't say most, but in a lot of cases, those rights are merely infringed. Now, to set up an infringement in a lawsuit, what really is required to be proved or established to set up a valid claim of infringement in a lawsuit before a court of law? Let's understand that. Let's start with what is the most basic, which is the all elements rule, the easiest to understand. So like Prachi introduced to you, different parts of a patent document, right, from your abstract, specification to diagrams and to claims. Well, claims being the most important part of a patent document because that's the scope of protection. So your rights essentially vests in the claim. The claims could be narrowly granted or widely granted. Prachi has spoken about it, so in the interest of time, I'm not going to repeat it. But what we have to do in order to set up an infringement, a valid claim of infringement, or a claim of infringement which is going to go through to prove infringement, is to pick up the scope of rights, to pick up the claim and understand its, or establish, or if you put it more technically, construct the true scope of a claim. Now, how can you construct a true scope of a claim? One way, and which is the most common way, is to identify the elements of the claim or essential elements of the claim which you are enforcing and using to establish infringement as against a product, an infringing product in the market. Now, with this identified elements or essential elements of the claim, what do? We start mapping it on the product, the infringing product. Well, one caution which has to be raised here, which although may be very sort of logically understood, but had to be clarified because many mistakes were made in this domain even before the courts of law. It came through, the caution came through Roche versus Cipla, and it clarified in absolute crystal clear nature that what has to meet a claim of infringement, what has to be done? The mapping of the claims, which is the scope of protection afforded by the claims, has to be done on the product, infringing product. So it is claims versus product, infringing product, I mean. It's not the patented product versus infringing product. Because as we know, and we've spoken about it in great detail, the rights and the scope of protection are in the claims. So what is infringed is not a product coming out of the rights, but your rights. So it has to be right versus the product. That's the correct mapping. Now moving on. We take the essential elements or the elements of the claim, map it on the infringing product. If there's an exact match, that's the luckiest scenario. Bingo, it is literal infringement, which can be directly proved before court without much hassle. However, the courts are mindful of the fact that in such fields, it's not just the patentees who are greatly, who may possess some sort of ingenuity, but even the infringers are smart enough. There may be very trifling changes they may make in the elements of a claim, and and try to get within the ambit of technicalities of the language of the claim. Well, the jurisprudence acknowledges that cannot be permitted. What happens is in a case like that, we have a concept. That concept is called as doctrine of equivalence. It's a legal rule, very well established legal rule, wherein the courts acknowledge that a patentee's effort or the patentee's so much investment into a granted invention cannot merely be taken away by an infringer who's going to make very unsubstantial or minor changes or some kind of a change which may just take it out of the scope or the construct of the claim, but still may be infringing, still may be the same product. What happens in such cases? Such cases, what basically is done, when the mapping is done, the elements are mapped on the elements of the infringing product. Now, when the elements are being matched or mapped, the element is seen. If it a substitution is created for an element or any of the element of a claim, that substitution has to be assessed on a 3-identity test which came up which the Supreme Court in the US came up in the Gravertan case, which simply said, if the substitution or a replacement is done in substantially the same manner to perform substantially the same function and to achieve the same result. If I can take a very old example here, is to possibly replacement of a spring, a metallic spring with an elastic band. They do essentially more or less do the same stuff. They are doing this, performing the same function in a device, maybe situated in a way, in the similar way, and bring about the same result. That substitution or replacement will be considered as an equivalent of the element, and if such mapping is done with each substituent, then a claim of infringement can be set up successfully. Now, in a claim of infringement, there's a burden of proof which which in any civil lawsuit or in any lawsuit, in any enforcement action, has to be ascertained for establishing a claim. Now, general parlance, burden of proof is on the patentee, with a slight exception in process patents, where 100 section 7A says that in certain cases, subject to fulfilling of certain criteria, the court may direct an infringer or a defendant to prove that the process employed by that defendant is different from the claimed process, which is the patent process. These are two criteria which are laid down in 107A, and I would request everybody to go through. We can take questions on it if there are. In the question answer round, we have to really, I think, rush in the interest of time. Okay, Devesh, go on.
We are on the relief now.
Relief, right? Since it's not, yeah, now I have it showing on my screen. Okay, I'm going to quickly browse through these slides. They may be not my most favorite slides, so just bear with me. But it's important for everybody to know that the rights in a patent can be enforced through civil actions. There is no criminal remedy available under the Patents Act. And the reliefs could be permanent injunctions, preliminary injunctions, which are interim injunctions, damages at the end of the lawsuit when the trial is concluded and infringement is found and the plaintiff or the patentee is found in, fit to be for the grant of damages. Destruction of the infringing goods, the costs or the attorney fee, everything that is spent on the proceedings, that can be given, an award can be given for that. Next slide, Devesh. So damages in patent law, it's more or less similar to all IP cases, the damages, except for one very, very, one aspect which is very unique, which comes in at every stage of a patent, which is public interest. Now we are aware that was always read against the patentee and in the interest of larger public for the access of medicines. With Merck versus Glenmark, the DB decision, public interest, especially when the pricing of the drug was not of an issue. I mean, there was not a very big delta between the infringing product and the innovator product. In that case, the court read that the public interest was in the interest of the patentee to protect, otherwise the market will for all times to come be spoiled for the patentee, and that may also have an impact for further research being conducted by the patentee for in the same field or for other drugs. So let's, if there are more questions on that, we can take it during the Q&A, and we can now zip through so that Udita can be brought up. Next.
If we are on kinds of enforcement actions now.
Yeah, so the kinds of enforcement actions. Yeah, all right. Very broadly, two kinds where there's an actual infringement which has taken place in the market, and a key ultimate action where an apprehension that there is an infringement likely to take place, which if not prevented, will not be considered an adequate remedy, or damages may not be sufficient to make good for that. Well, patent lawsuits with after 2015 are considered commercial disputes and are guided by the principles and the procedures laid down in the Commercial Codes Act, which may deviate from CPC in a lot of instances. Next, this is the last thing that I'm going to address before I pass on the baton to my colleague Udita. Well, we've seen the rights, we've seen the lawsuit, we'll see what's required to set up an infringement. What are defenses available in a suit for infringement? Of course, non-infringement, which is which can be that the patentee has failed to set up a valid or a proper claim of infringement and has not filed enough evidence, or that the defendant has been able to show with some sort of test results or something that it is not infringing. One example here, during the entire saga of Ross Cipla, at one stage the court said, for a polymorph patent, you ought to give infringement. It's not enough to prove infringement. You have not discharged your burden, and therefore the claim goes. Well, of course, when we went through that, it was the very end of the saga. Yes, infringement was, the claim was held successful. Well, all the challenges which are there under the Act for invalidity are available as a defense to infringement. But of course, the proof that is on the challenger or who challenges the validity of the patent. Enough jurisprudence on this part which says that once there is a credible challenge established at a prima facie level to a claim to a validity patent, no injunction, no temporary injunction must be granted. But of course, everything is wavering at the moment. We have cases saying that, and we also have cases saying where the infringement is met and there is no credible challenge. Injunction ought to be granted. Damages may not be effective remedy. Well, Bolar exemption, well, it is section 107A, which permits certain activities that are permitted despite there being a patent under the Act, and which will not amount to infringement under the Act. In international jurisprudential terms, it is called Bolar exemption. The purposes of the activities which are permitted are solely research and development activities, or for the purposes of obtaining regulatory approvals or regulatory requirements. However, such activities are not freely done. Very recently, the court in Bio versus Union of India laid down safeguards which did provide for certain providing for certain information to the court and to the patentee to ensure that there's a claim, or there is whenever there to substantiate the claim that the activities done by the infringer is protected or is allowed or permitted under the Bolar exemptions under the Act. One last thing, then before I invite one more thing, like section 48, section 107 also does not mention permitted activities with respect to exports. The word export is missing 107A. Buyer held that exports is included within the ambit of 107A. That means those permitted activities can also be extended for exports. With this enforcement bit of the Patent Act at a preliminary level, Prachi and I have attempted to establish. Of course, each slide is a masterclass in itself. But in the interest of time, we will want to conclude the first topic here, and I would like to invite Udita, who I would like to pass on the baton to, introduce the next topic and address the audience on it.
Yes, thank you, Ms. Fisha and Ms. Prachi, for that enlightening discussion. We're running behind time. We have some questions for you, but because we're running behind time, we'll first take up the next topic, which is being addressed by Ms. Udita, and then we'll address the question and answers. So, Ms. Udita, tell us why the territorial jurisdiction in IP is so peculiar, and why one needs to learn about it, and what's so different from general civil suits in this. Over to you.
Thank you, Tusha. Thank you, Devesh. Good afternoon to Dr. Rawanle and everyone. Now, territorial jurisdiction is a very important aspect of all litigation. And the basic purpose why courts have devised this is to ensure that, can you go to the next slide, please, Devesh? The basic purpose is to ensure that all parties get fair opportunity and nobody is put to an inconvenience. How important is territorial jurisdiction? Well, a judgment which is rendered by a court which does not have jurisdiction is considered a nullity. And this defect cannot be cured by even consent of parties. Therefore, jurisdiction is very important. And whenever you file a suit, the first thing that the defendant does put forth is objection to jurisdiction. And when such an objection to jurisdiction is taken at a demurrer stage, the courts have held It's a very well established rule that you have to look at the contents of the plaint, and the contents of the plaint are taken to be correct at that stage. Therefore, drafting of the plaint becomes very important. And that's, in fact, when we present plaints to the court and file plaints, we have a specific paragraph which we always draft to show how the courts have jurisdiction. Now, how do we draft this paragraph? We take into consideration the different relevant facts. What are the relevant facts are decided by the rules of jurisdiction which are contained in the CPC, as well as the various special statutes. In this particular case, the special statutes would be the Trademarks Act and the Copyright Act. Now, coming to the general rule, a rule which is applicable to all civil suits and not only intellectual property suits, is Section 20 of the CPC. Next slide, please, Devesh. I don't think the slide has changed.
We are here with the slide is changed. Yeah.
So Section 20 basically says that a civil suit can be filed, number one, where the defendants reside, carry on business, or personally work for gain, or where the cause of action or any part thereof arises. Now, when we come to intellectual property suits, the defendant more or less generally is a corporation. So what the phrase of Section 20, which really becomes important, is carrying on business. And what is carrying on business is defined by under the Act itself, under the explanation to Section 20, where it says that defendant corporation is deemed to carry on business as sole or principal office or a subordinate office where the cause of action has also arisen. Now, the Supreme Court in the case of Patel Roadways basically explained this explanation and said that this explanation only provides an alternative locus. It does not provide an additional locus. What does this mean? That means that if a defendant has one office, which is a sole office, that's where it carries on business. But where a defendant has more than one offices, that's where things become complicated. And in such a case, the plaintiff will have to go to a place where there is a overlap between the office of the defendant and the cause of action. Now, this office may be a subordinate office, maybe a principal office, but you have to, the entity, the defendant, is deemed to carry on business only at that particular office of its. Now, coming to the next slide, please. Now, coming to what is cause of action. You have carrying on business, where the defendant is carrying on business. The second is, where has the cause of action arisen? What is cause of action? Is a bundle of all facts which need to be proven to show that the plaintiff has a case and has can be granted a relief. These include all the material facts on which the right itself is founded, as well as all the material facts which relate to the infringement of this right. A very interesting concept, and Tushar touched upon it a little bit, was the concept of qua timit action, where a suit is filed not because of a harm which has already taken place, but because of a threat of infringement of a right. In such cases, jurisdiction is where the threatened infringement is anticipated or apprehended. Where there is a commercial launch of an infringing product or infringing sale of products which infringe the trademark, that's where when the plaintiff apprehends that there would be something like that happening, you can file a suit. You don't have to wait for the threat to materialize. Now, in the Teva versus Natco case, this was a patent infringement case, where, as I had mentioned earlier, the court said that we will look at the contents of the plaint, and the jurisdiction, if we decide that the contents of the plaint disclose that the court has jurisdiction, that jurisdiction will not be ousted just because the defendant has averred to the contrary. That would be left at the stage of trial. The court will still have jurisdiction till that stage. Coming to the next slide, please. So all this was the general rule, which is applicable to all civil suits. We come to what are the special rules for intellectual property cases. So there are Patents Act does not have this special rule. It's only the Copyright Act and the Trademarks Act, Section 62(2) of the Copyright Act and Section 134(2) of the Trademarks Act, which provides a special forum for trademark and copyright disputes. And it says that wherever the plaintiff resides, carries on business, or personally works for gain, that jurisdiction would have, the courts in that jurisdiction would have jurisdiction to decide on that matter. Now, this is important, and why was this brought in? Because it was seen that small businesses and authors found it very difficult to enforce rights where the cause of action arose at a place which is very, very far away, or the defendant resided at a place which is very far away. So to ensure that the plaintiff does not get deterred from enforcing his rights, that's why Section 62(2) and Section 134(2) were brought into the respective acts. Now, what this provides for is long-arm jurisdiction. Why long-arm? Because it is providing jurisdiction to the court to adjudicate upon disputes where the person is situated outside its territorial limit. In this case, the defendant is outside the territorial limit. Courts have also said that these are additional grounds. These are over and above available to a plaintiff, over and above the Section 20 grounds, and that the plaintiff therefore can go under the general rule, which is provided under Section 20, or it can go under Section 62(2) or 134(2) of the respective acts. Now, again, a phrase which takes on relevance here is what is carrying on business. And the Doda House, in the Doda House case, the Supreme Court said that the plaintiff does not have to be personally present in a particular jurisdiction to carry on business at that jurisdiction. The plaintiff can carry on business through an agent. But it laid down 3 conditions. First thing it said was that the agent should be an agent in the strict sense of the term. That is, the plaintiff would still retain control, a voice, a say in the operation of the business that the agent is carrying on. Second is that the agent will be attending to the business of the plaintiff exclusively, and the business would be carried on under the plaintiff's name. The third thing is that at that place, an essential portion of the business of the plaintiff must take place. So this is basically what Section 62(2) and Section 134(2) entail. Now, what happened in 2015 is the Supreme Court in the IPRS versus Sanjay Dalia case restricted the scope of these 2 sections to a great extent by reading in the explanation to Section 20 on what amounts to carrying on business. Please come to the next slide, please, Devesh. I don't think I can see the next slide. Yeah. So what the Supreme Court in IPRS versus Sanjay Dalia said, that like to ensure that the plaintiffs and the defendants are put at the same status, what happens is where there is an overlap, like in the case of explanation to Section 20, wherever there is an overlap between a plaintiff's place of business and the cause of action, the plaintiff has to necessarily sue there. Now, this particular principle, which came into being by the Supreme Court